declared to have been to have vacated his seat. This parliament again too, his seat has been vacated. One person. He suffered a lot. So, my lady, and my point is that no matter the number of times an unconstitutional act is repeated, it does not ripen into constitutionality. This court has said in numerous cases. Yes, this court has said in numerous cases. It started from before the Attorney General up to the recent matter, I think ex parte charge also. Yes, ex parte charge. 2007, 2008, Supreme Court of Ghana report, volume 1, at page 213. That an unconstitutional act, no matter the times repeated, respectively, does not ripen into constitutionality. So the fact that the previous speaker had ruled that Mr. Esema Mwaku had vacated his seat, and that is being sought to be used as a precedent today, does not mean that it's constitutional. Especially, I'll be done on this case.
You had only 3 issues.
Yes.
And you have addressed them.
Well, I say that the court has the power to issue orders, and the orders and directions issued by the court shall be binding on anybody at all. Ex parte charge held same. Republic vs. High Court, Fast Track Division, Accra, ex parte Commission on Human Rights and Effective Justice, which is an interested party. The court held at page 296 per Georgina Wood, CJ, that in relation to this matter, I think this was Dateba GSC stated that in relation to this matter, we need to remind ourselves that there is no parliamentary supremacy under our constitution. Rather, it is the constitution that is supreme. As the interpreter of that constitution, this court's view of the meaning of a constitutional provision cannot be preempted by that of any other agency of the state. In short, a provision in the constitution means what the Supreme Court says it means, and not what even Parliament has declared it means. I end on this note. The Supreme Court's power to interpret the constitution has been long upheld from Benjamin Awuno Williams, 1970, over 54 years ago, up to date. The constitution means what the Supreme Court says it means. End of matter. Thank you very much.
It has been expressed that around the table that you are not allowed to speak, and yet the Attorney General has spoken extensively. I'm sure there's nothing you want to add. I'm very sure there's nothing you want to add.
My Lord, unfortunately, I agree with the sentiment that was expressed around the table, but I will not bore the court with adding anything.
We agree.
But I agree with the sentiment that was expressed. I think the Attorney General extensively referred to matters that was a statement of case without it being stopped. But you know,
Council, why are you pointing there? The sentiment actually came from there.
My Lord, Justice Tampo, we know each other well. So I don't want to point someone.
But I was the one who stopped you, and I had made that sentiment that I think that if the Attorney General has had so much time to speak, I think that if you want to add something further, you should be allowed.
I'll just add one thing. I think I'll just simply add one thing. What I'll add is that, my Lord, the provisions of the Constitution with regards to the underlying principles that is established with regards to democracy, the establishment of democracy. If we interpret Article 97(1) G and H, my Lord, just now go. No. I haven't talked about the regular. No, it is not. My Lord, you know, there's no art of finding a man's construction and a man's face.
Please finish
Yes.
your submission.
My Lord, should it be interpreted in a futuristic manner, it will totally undermine the rights of an individual to freedom of association. And Article 21 of the Constitution. It will mean that once you come into Parliament under one party or as an independent, you must remain there forever. That is simply, my Lord, what I want to add. And I thank you for the opportunity.
Mr. Dantis, so your memorandum of issues, the 8, you still think they are all germane to the matters we are hearing? The 8 issues that you've raised, you haven't said anything about it. Nobody has said anything about the memorandum issues. So I just want to know whether all the 8 issues that you've raised.
My Lord, just as the reliefs, we focused on the reliefs relating to Article 97(1) J and H. The memorandum of issues 2, we will end at issue 4.
But 5, 6, you've mentioned Article 97(1) J and H. So if you end 4, what are you telling us?
We consolidate 1 to 4 deals with the vacation of office. At memorandum 5 deals with whether the Speaker has the power to give the ruling he gave or not. And my submission that he doesn't. We've addressed this sufficiently in our statement of case.
Okay. Thank you.
Thank you.
Yes, yes. I think I consider this issue to be very germane.
Okay. Thank you. Sit down.
Mr. Gatti, I think I missed something. Did you say you are relying on your first to fourth issues and abandoning the rest?
My Lord, I'm saying that first 1, 2, 3, 4, taken as one, determines all the issues before the court.
So we should not expatiate on 5, 6, 7, and 8. Pardon me?
But issue 5 is also relevant. Issue 5 is also relevant, and we've addressed it extensively.
Issue 5 is also relevant.
Yes. And then issue 8. 6 and 7 can be abandoned.
By court, the judgment of this court will be delivered tomorrow, 12th November 2024. Yeah.
My Lord, I'm most grateful.
Lord, we are grateful. Well, I mean, of course, being entirely the prerogative of the first defendant to file anything at all. Respectfully, I think that if the first defendant came before the court at the last agenda date, represented by counsel made representations before the court to file submissions at a certain point in time, elects not to do so, and then for no reason at all elects also to appear before the court. Clearly, that is disrespect to the court. I made this observation because I'm the Attorney General, leader of the bar, and all that. Such conduct, with all respect, should not be tolerated by the court.
Leave it to us, Mr. Attorney General. Leave it to us. I would rather advise that as a member of the bar for which you are the leader, you should reach out to him at the close of this proceedings to find out if everything is all right.
And indeed, my friend, the Chief State Attorney, reached out to him on Friday to find out if processes had been filed by him. So now, I bet. Hardly did we expect that he would not even show courtesy to the court by not showing up. Thank you very much.
Honorable Attorney General, I think at the last agenda, if my memory serves me right, you also said, when we asked that you should file processes, he said he had instructions to deal with the matters that he did, and then
he will go for further instructions.
So, if he has not been employed again,
no, but my recollection is that that was before the firm agreement and then statement as to when process should be filed by the court. That was before it came. But that's fine. Maybe that's fine.
We have a lot
to deal with. That's fine. I'm very grateful.
Yeah.
Right.
So if we retire early,
right,
because of the public interest in the matter, we should be able to serve the people in whose sovereignty.
Precisely. I agree. I'm grateful.
Before you rise, my client, as we were arguing, the plaintiff came in, so we'll be grateful if it's possible.
We have signed the record.
Panel will be reconstituted. All rise.